on the first week of the every month, where we discuss the regulatory recap on corporate securities and insolvency law since last month up to the date of this webinar. We have been receiving constant feedback on this webinar and we are trying to evolve as much as possible and try to add new areas where we can share updates and discuss these things with you. So we'll keep on looking for your feedback and we'll keep on improving this webinar. Thanks for your active participation all the time. Apart from the recap, we'll also discuss on, we'll take your queries on all the latest amendments or the changes that have been there. So this also serves both as a medium to discuss what has happened during last month and to discuss your queries arising out of those amendments. Apart from these, all these amendments that we discussed today are also available as a part of our fortnightly update that we shared with all of you, named as CP Connect. So you will find all those things that we discussed today as part of the CP Connect, along with the presentations that we will be sharing with you post this webinar. So to discuss all these regulatory changes, we have a healthy panel of experts with us, with Mr. GP Madan. He's a very regular feature in our webinar, partner of Madan Law and seasoned professional and practicing in IBC laws since long. I welcome Madan sir. And then we have Mr. Ravi Prakash, who is an associate partner at Corporate Professionals, heads the legal and litigation team. And he will be discussing his views on some of the recent judgments of various courts. Then we have Mr. Manoj Kumar, is the partner and head transaction advisory, looks into M&A, regularly attending all the webinars, and along with Ms. Anjali, who heads the capital market division at Corporate Professionals. Both of them will sharing their respective views on the recent changes in M&A, IBC regime, and capital market. So to start with, I will begin with the latest amendments in the corporate laws. Then we'll hand over to Mr. Madan to discuss the changes in the IBC, specifically the recent discussion paper that have been issued on the law. And then thereafter, each one of us, Manoj, Anjali, and Ravi will take care of each of their respective relevant chapters and discuss their views. And thereafter, we'll take your queries, whatever you post on the chat box available to you, and otherwise the queries that we have received offline. So to begin with, I am sharing you the recent updates on the Companies Law, that is Companies Act. So last month have been a very eventful month for all the practicing or professionals who work under the domain of Companies Act, since the new version 3 was launched on 23rd of January. So beginning 7th January till 23rd January, there was a blockage on the filing of certain forms around 56 forms that were supposed to be introduced as part of the new version 3, which is government is introducing in phase-wise manner. So as part of that, the system was not working from the date of 7th to 22nd January. Accordingly, a ministry issued a circular whereby they exempt any additional fees with respect to any filings that were due during this period. Though the problems continues to be there since every new change is subject to certain restraints and certain issues. So there are those issues which are still there in the MCA system, and professionals at large are facing issues. I believe MCA is rigorously looking into it, and our institute has also requested the ministry to extend the additional fees exemption for a certain more period, considering the practical issues that are being faced in filing various forms. So this is with respect to the e-form. So when the new system, Shivam, move. So as I mentioned, new forms were issued. So by way of various notifications on 23rd January, all the existing forms that were supposed to be filed under new version 3 form, there were 56 forms. So all these forms were issued as part of different amendments and different rules across the chapters under the Companies Act. So all these new forms have been introduced. While majorly all forms are written substance are same, what we used to file, though the filing medium and mode has changed. And there are certain edits and certain new changes in some forms too that we will be discussing going ahead. So this is a list of all those forms, 56 forms that are now being filed under the new mode, and that is the version 3. Thereafter, along with the various amendments that are being made in order to introduce new forms under the rules, certain ancillary amendments are also proposed to with respect to the disqualification of directors. So currently, there is a requirement of filing Form DR8 with the company in case you incur any disqualification under subsection 2 of 164. That predominantly deals with disqualification arising out of non-filing of your financial statements for 3 years, or non-payment of your interest or debentures or preference shares. So for that, there is a Form DR8 that is supposed to be filed every year, and along that is generally filed in the beginning of the year, where you certify that you're not disqualified under those provisions. So there is now this disqualification is also declaration is also required to given with respect to the disqualifications covered under subsection 1, which talks about disqualification arising out of you being judged insolvent, or you being disqualified by order of any court or tribunal. So there are a list of disqualification that are mentioned. So you also need to give a declaration that you also don't fall under any of those disqualifications. Apart from this, if you are disqualified under any of the disqualification under 164, now there is a specific requirement. Once you disclose this to the company where you are director, then the company is supposed to file a Form DR9 with the ROC within 30 days of receiving the declaration from the relevant director that he or she has been disqualified under the relevant provisions. Earlier, there was no such intimation that was required to be filed by the company to the registrar of companies. And generally, most of the disqualifications were actually triggering on account of the notices or the strike off that the ministry were doing. But apart from it, even if your company is not being striked off and you are falling under that requirement of subsection 2 of 164, then the disqualification also incurs it automatically. So you are bound to disclose that to the company. Now, whenever you disclose such disqualification, the ROCs and the company is bound to disclose the same to the ROC within 30 days in Form DR9. Application for Form DR10 is also introduced, where you can file application for disqualification. Once this disqualification, so once you're disqualified under Section 164 subsection 2, the disqualification is for a period of 5 years. After that, if you want to remove that disqualification, once the period is over, you need to file this application to the regional director in DR10. Earlier, this was required to be filed, I think, with ROC. Now it is with RD, I believe so. Next.
It means, Ankit, on the portal, there is a facility to file forms with RD also.
Pardon, sir?
There is a facility of filing the forms with RD on the portal.
Yes, you can. There are forms RD, there are forms you can file which goes directly to the RD along apart from ROC.
No, but RD1, those forms are starting with that term RD. This remains DR10, but it is required to be filed with RD. Not with
so it's an online form. I believe they would be, so
that's
as of now, there is no such online version, but I believe they would be coming up with some online version also.
Okay.
Some, apart from as a part of the changes in the forms, some other changes have been made in terms of the incorporation and conversion process. So first, with respect to whenever you are now filing an application for conversion of company into any other form, generally you are required to file an MOA AOA as a part of the attachment to the relevant form. Now, similar to the one MOA, EMOA, EAOA, as you file in case of incorporation of the companies as part of the form SPICE, you are supposed to file a similar form as part of the conversion of the companies too. So if you're converting from one form to another, the MOA that you will be filing, it will be filed in form of an EMOA or EAOA. Then a consent was required from the nominee in Form INC3, which was supposed to be filed in case of OPC. That consent has now been dispensed with. Specific provision has been made in the form itself. So one has to give a declaration there only. Then with respect to conversion of OPC into private or public company or private to OPC, there were requirement of filing resolution, list of proposed members, directors, list of creditors with the form and application. All those things have been done away. You need not to submit all those with the regulator now. Further, similarly, in case of incorporation and conversion of section of a company into Section 8 company or incorporation of a Section 8 company, certain declarations were required by the applicants and professionals. All those declarations have not been removed, and they have been removed in terms of physical form. They have been incorporated in the form itself. So when you will be filing the form, you will be making those declarations in the form itself. Similarly, in case of conversion of a company into Section 8, when you incorporate generally Section 8, there was a requirement of filing an estimation of your future income, then income statement for last 2 years, board report, audit report. All those things have been done away. While financial statement, board report, audit report have already been available with the registrar in terms of the past filings by the company. The thing that is generally not available is future income and expenditure statement, which are supposed to be filed. But that is also now have done away. So that will also further ease the process of conversion of a company into a Section 8 company. Further, similar, there are other things like once you file an application for conversion of Section 8 company into any company of any other kind, you are supposed to file an application to RD and ROC both. Now, the application requirement of filing an application to ROC has been dispensed with. You will file application only to RD. And through the system, the RD office will share these application to the ROC. And there were certain declarations that were required from practicing professionals. So they are also dispensed with, like previous amendments, have been incorporated as a part of the form itself. Similarly, with respect to conversion of LLP, partnership, society, trust into a company, major amendments have been made. There were a lot of requirements of submitting a lot of documents along with the application in terms of consent, undertaking of the proposed directors for Indian Stamp Act, declaration. All those things were required to be filed along with the conversion documents. All those things have been done away. So the process have been made quite simpler as opposed to what is there now. Similar to conversion of Section 8, where we file an application with both ROC and RD. In case of shifting of registered office, we also file an application with both ROC and RD. So therefore, application of physical application filing of application with ROC has been removed, whether in form of general one or any other form. So the RD will now submit the application to ROC through the system itself. So there is no requirement of filing a separate application. Next. Further, with respect to status of obtaining application for obtaining status of development company, there also a major rationalization have been done. Requirement of filing board resolution, special resolution, auditor certificate, statement of affairs, all these have been done away with respect to filing of the application for status of a dormant company. The process has been simplified so that you can easily obtain the status of a dormant company if you meet the eligibility criteria as outlined under the section. Some other changes. So there have been major changes in Form DI 12. There have been a long pending demand with respect to companies which are under IBC, where RPs and IRP filed difficulties in filing forms because of their name not being on the signatory list, or there is a process of filing an INC 28 through their name is added. Now, in the Form DI 12 itself, a provision has been made in case of appointment of an RP and IRP. The details can be filed in the Form DI 12, similar to a director, CFO, company secretary. And then as a result of their name being added in the repository of MCA, they will also be eligible to sign various forms that are filed during their tenure in terms of compliances that are required under the Companies Act. So all these forms they can also sign. Similarly, in Form DI 12, where there was a requirement of filing a consent to act as a director in Form DI 12, there were cases where it was seen that forged documents have been filed in past, where a person's forged consent was filed as a consent to Form DI to the Form DI 12, and he was appointed as a director without actually receiving his consent. Now there is a process which has been introduced in the Form DI 12 itself, where the consent has to be obtained of the director in form of his signatures. So the director who is proposed to be appointed is also supposed to sign the form by way of giving consent in Form DI 2. Similarly, in case of DIN application, a specific field has been added for jurisdictional police station. So now when you are applying for a DIN in terms of your residential status, you have to also disclose the details of jurisdictional police station to the Ministry of Corporate Affairs. Now moving ahead to consultation on insolvency law, the recent paper that has been introduced by IBC. We have with us Mr. GP Madan to share light on the same.
Ankit, may I share my PPT if you have?
Yes, you can also share. Shivam, you can give rights to Madan sir to put his own PPT. You can pull down this right now.
Thank you. Is it visible, Ankit?
Yeah, sir, you have to just put it on slideshow.
That I'll do. Just a minute.
I think you need to go on the slideshow tab. I don't think any link given in the bottom. Just go on the slideshow tab, sir, on the top. Just beside animations.
There is some issue with me. Just read it out.
No issue, sir. You can play it like this only. You can play that in the non-slideshow version too.
That's visible now?
Yes, it's perfectly fine.
Thank you. Thank you, Ankit, and thank you, corporate professionals, for inviting me to this webinar on latest updates on IBC. Friend, this is a discussion paper which has been brought by Ministry of Corporate Affairs on 18th of January 2023. And this discussion paper has been brought by Ministry of Corporate Affairs, which includes the proposed changes to be brought in by the government in the Insolvency and Bankruptcy Code 2016. And through this discussion paper, the government has sought suggestions from the stakeholders. And the last date of giving you suggestions is 7th of February, 5:30 p.m. Just a minute. Yeah. In the month of November and December 2022, Ministry of Corporate Affairs had discussions with various stakeholders. And on the basis of those discussions, the suggestions which were received and the recommendations which were received, and further, on the basis of various judicial pronouncement under the code, which some of them have actually derailed the success of this legislation, and also on the basis of some regulations, because there have been issues that it has been seen that regulations are having overriding effect over the main body of the legislation. So it has been decided that to bring the main those regulations in the main body of the law. So taking into consideration all this, the ministry has proposed let there be some changes in the Insolvency and Bankruptcy Code. And whenever any change is made in a law, a bill is there, and the bill is tabled before the cabinet and ultimately before both the houses of the parliament. But here, what the government has done, and I'm really thankful to the government, that before bringing this amendment bill, the government has brought this discussion paper. And on the discussion paper also, the government has sought suggestions from the stakeholders. And after seeking the suggestions of the stakeholders, that is last date, as I said, being 7th of February, the government will come out with the amendment bill. And I am sure that amendment bill shall also be thrown open to the public, to the stakeholders for their comments. And on the basis of those comments, then the bill shall be finalized and palatable before the Parliament. And as per the information received by me, in the second half of this budget session, this bill may be introduced in the Parliament. So that is why the government is acting very fast, and 7th February has been kept as the last date for receipt of the suggestion. Now, some of the discussion paper is having very laudable issues, and I really welcome majority of these issues. Now, what are these issues? And today, no doubt, we will not be having time to discuss this discussion paper. I'll be putting before you all these some of the highlights of the discussion paper, and later on, you may write to us, and from corporate professionals, we will be submitting our suggestions to the government on the basis of the feedback received from all of you. Now, the government has said in this discussion paper that as on date, Ministry of Corporate Affairs, IBBI, Information Utility, Insolvency Professionals, all of them are using a different platform, digital platform, for filing the application, for filing the reports, or maybe IBBI is while dealing with the insolvency professional, or for storage of the records. So it has been decided that there shall be one single user-friendly platform for all the users, so that multiplicity of the filing of the reports or of the communication channel, that should be brought into one particular single user-friendly digital platform. I think it's a laudable objective. We need not give any suggestion to this, rather we should accept it, because the suggestions will be given when the amendment bill is before us. Another suggestion is there in the discussion paper with respect to admission of CIRP applications. You know, as on date, every financial creditor is mandated to give the information of the debt provided or financial assistance provided to the information utility. But now it is proposed that even an operational creditor shall also be mandated to submit this information with the information utility. And unless this information is there on the information utility platform, the application of this operational creditor under section 9 of the code shall not be entertained. Now, whenever any information is provided by either by the financial creditor or by the operational creditor to the information utility, the corporate debtor shall be given an opportunity of being heard that we have received this information from the OC or FC, as the case may be. Now you please authenticate whether the information which has been given to us is right or not. And for this authentication purpose, a special time window shall be provided. And if within that time window, if the corporate debtor does not respond, it shall be presumed that the information which has been provided by the OC or FC is genuine, and that shall be taken on record. And then whenever any application is filed under section 7 or 9 of the code, the adjudicating authority shall rely upon this information which is there with the information utility. And at that point of time, the CD will not be having any defense to object to this information which is there with the information utility, because the IU will be having this information of debt and default both. So once the debt and default is, yes, Ankit.
A small point. So there is already a concept of information utilities. So what is the current obstacle, or what is the current reason why they were not able to rely?
No, current, it is being relied upon. It is being relied upon, but the OCs are not giving any intimation to IU. Now it is being very mandatory for OCs also. Okay. Till that is mandatory for FCs. But in some cases, we have seen the FCs are also not providing this information. But once this amendment is made, then it shall be mandatory on the part of adjudicating authority also to rely upon this information. And unless this information is there with the IU, the application shall not be entered in by the adjudicating authority. That's the change. Okay. Section 7 application, it is being stated now that adjudicating authority to admit the application if the debt or default, as the case may be, is established. Now you will be wondering that what is new in this. The new in this is that if you read very minutely, section 7 subsection 5 of the code, it says even though there is a default, the adjudicating authority may admit the application. And while in case of section 9 subsection 5, in case of operational creditor application, it is written there that adjudicating authority shall admit the application. And recently we have seen in the month of July a landmark judgment in Vidarbha Industries case from Honorable Supreme Court of India, where Honorable Supreme Court of India said that it is the discretion of the adjudicating authority to admit an application under section 7. It means the adjudicating authority may or may not admit the application. And after that, the rules of the game with respect to even section 7 application have changed. Before Vidarbha Industry judgment, everybody was of the view the moment we have debt and default, the application shall be admitted. But now Supreme Court has said, no, it is a discretion of the Honorable Adjudicating Authority. And what actually happened in Vidarbha Industries case, I'm just giving you a ballpark figure. Suppose the total amount payable to the financial creditor was 100 crores, while amount recoverable from the government was 200 crores. And it was established. Yes, central government owes this money to the company, and company was asking, company was after the government, please give us this money. And suppose this 200 crore rupees comes to the company and company pays off to the financial creditor of 100 crores, company will be cash rich by 100 crores of rupees. But because of that money was not forthcoming, the operations of corporate debtor was not in a position to discharge its liability. An application is filed and application was admitted. Ultimately, matter went to Supreme Court. Supreme Court said, sorry, this company is not an insolvent company. This is a solvent company. And you cannot take any solvent company to insolvency. But now the government wants, again, the rules of the game to be very, very clearly defined, that the moment a debt and default is established, the company shall be taken to insolvency.
But as a result of
if
this
you ask me personally, I am not in favor of this particular amendment.
No, but sir, as a result of the judgment of Supreme Court, were there any major cases where NCLT exercising its discretion have not agreed to admit the application?
But now, after this judgment, in every section 7 application, the corporate debtor is there raising objection to the application that I am a solvent company. I have so much of receivables. So please, this application should not be entered and should not be admitted. So now the government is going to make it very clear. The moment you have debt and default, the application shall be admitted.
Discretion is being removed.
But to me, the intention, the objective of the IBC is rehabilitation, revival, restructuring, resolution, not recovery. But by virtue of this amendment, it shall become a mere recovery, because the adjudicating authority will not have any discretion at all.
I think then there should not be any even need to admit.
Let's see, because from the chamber also, I am giving this suggestion that industry is opposing this proposed amendment. Okay, then if you see the Insolvency and Bankruptcy Code, it is said there, once this application is filed under section 7, 9 or 10, the default shall be established and within 14 days, and the application shall be disposed of within 14 days. But this 14 days period is absolutely impractical. I have not seen even a single case during last 6 years where an application has been disposed of in, say, 14 days, because principles of natural justice have to be followed. If an application is there, the notice shall be issued, a reply shall be there, a rejoinder may be there, then the arguments have to be heard. All this cannot be completed within 14 days. In many cases, we see even the service of the notice is not done within 14 days. So where is the question? And then we are not having infrastructure also at the adjudicating authority level. How can we think of the 14 days admission? Today, I tell you, in the principal bench, before lunch, just one item could be heard, item number 1. So how can we say that within 14 days, the application shall be disposed of? So that is why the government is trying to provide some clarity on this, how this 14 days timeline can be applied. Actually, if we see that Supreme Court also in a number of cases have decided that all the timelines under the code are directory in nature. First of all, we have J.K. Jute Mill's case, which said all timelines for adjudicating authority are directory in nature. But in Rainbow Papers case in the month of September 2022, it has been said that all timelines under the code are directory in nature. If all timelines are directory, it means that will be the biggest failure of the law, because speed is the hallmark of this legislation. The moment we say all timelines are directory, it means nothing shall be done on time.
But by virtue of this discussion paper, is ministry not thinking to give a more appropriate timelines, or just want to keep 14 and give a clarification?
They have not said anything. They have sought the suggestions from the stakeholders. Okay. Section 10 application, which can be filed by the corporate debtor. It is being proposed that CD shall not propose the name of an IRP. An IRP shall be appointed once this application is admitted from the pool, which is being maintained by this NCLT bench on the basis of the recommendations received from IBBI. Okay. Empowering the adjudicating authority to impose penalties for violations of IBC. Till date, NCLT did not have any such power to impose penalties. Any criminal action was to be taken by the special court only, which has been established under the Companies Act 2013. But now it is being said that for a violation of any of the provisions of the code, NCLT shall be empowered to impose penalties, and this minimum penalty shall not be less than 1 lakh per day.
Per day.
Per day. It is a huge penalty. 1 lakh per day. And this may extend to 3 times of the loss caused or unlawful gain, whichever is higher. So 1 lakh per day becomes minimum.
But this can be only in case where the offenses are of continuing nature.
Obviously, yes. Now, suppose if you file an application, that promoter of the company is not cooperating with the IRP or RP, and he does not cooperate for three months together. So 1 lakh per day, so it will become 90 lakhs of rupees.
90 lakhs.
And that's the minimum. Even the NCLT will not be having any discretionary power
to remove them.
I think it's a too steep a penalty.
Yes, definitely.
That should not be the amount. And then if in any case, if a particular company which is under CIRP, if the promoters of the company are not cooperating with the resolution professional, in such a case, the promoters of this company, presuming if this company is MSME, the promoters of this company shall be debarred from submitting any resolution plan.
Anywhere else also?
Huh?
Anywhere else also?
No. In this particular case, if the company is under CIRP, company is MSME, so it means the promoters of the company may submit their resolution. They are not barred under 29A unless they are willful defaulter. So they are exempted under 29A. But if they do not cooperate, if their conduct is such that CIRP process is being hampered, then they may be debarred from submitting any resolution plan. Now there is some nice provision for fast track CIRP. It is as good as PPIRP we had earlier. In this case, the corporate financial creditors shall sit together with somebody, may bring a resolution plan, may approve this resolution plan with 66% of voting share, and now approach adjudicating authority at this stage. Company is not under CIRP. A plan shall be prepared, and now this plan shall be referred to adjudicating authority for its approval. Company is not, without taking the company into CIRP, a plan can be prepared and can be approved from the adjudicating authority. Yeah. And even the moratorium may also be sought. Without company taken to CIRP, moratorium may be there if the financial creditor approaches adjudicating authority. And IBBI will be authorized to specify a detailed procedure for all this. First of all, enabling provision will be there in the code. Then IBBI shall be authorized to lay down the regulations for this purpose.
So I think most probably this will be for us small, medium-sized companies.
No, for medium size, we already have provision. That's here, PPIRP. This provision is already there for last 2 years, but it is a non-starter.
So similarly, there was also a provision under the Companies Act when the liquidation provisions came, but it was also a non-starter.
Yes, yes. So similar. Now they are talking about that this PPI-RP provisions may be extended to some other categories of companies also, not only to MSMEs, but to other sector, other the size of companies also. And the voting share in PPI-RP now is going to be reduced from 66% to 51%. One thing which was a very major hindrance in case of PPI-RP, the promoters were to give an affidavit that there is no avoidance transaction in the company. And promoters were not willing to give this affidavit. क्योंकि ये ट्रांजैक्शन अगर नहीं होती ऐसी कोई तो कंपनी की हालत भी ना होती, बिकॉज कुछ ना कुछ वहां पे ऐसा है. So that, but now this provision is being omitted. That the promoter shall not be asked to give this affidavit. So that this is actually to activate this PPI-RP process, which was a non-starter one. In case of real estate cases, some nice proposals are there. There may be initiation of project-wise CIRP. Suppose within a company there are 10 projects. 9 projects are fine, but in one project the promoters are having difficulty, and in one project the financial creditors file an application. Now, for this one single project, why other 9 projects should suffer? So that is why the government is proposing that there may be project-wise CIRP process. Actually, earlier there were reverse insolvency pronounced by Honorable NCLAT, by Honorable Justice Mukhopadhyay. I think that may be introduced in the form of the provisions in the code. The other day I was delivering a lecture on this only, so I got somebody said that why should it be made applicable only in real estate cases? Maybe in the manufacturing sector also you may be 5 different projects, and one project is not running fine, all other 4 are running fine. So why for one project the company should be taken into CIRP? There also this provision should be extended that for one single project that there should be project-wise CIRP.
But I don't, will it be possible to make a very clear-cut distinction as opposed to a real estate, where the funding and receipts and all other can be very easily clubbed to a relevant project, as opposed to manufacturing units, where continuous receivables and payables?
But in case of real estate also, Ankit, there may be a possibility that you received money for this one single project and deployed this money to other projects. Then why those projects should not be under CIRP? You ordered cement and steel for one project, but deployed the cement and steel in the other project. Then why this project should suffer and go into insolvency? Why not the other projects which have actually...
But I think the
benefits.
The rationale might be that as a result of which the entire lot of the buyers get affected. In case that loss can be limited to a few, because other projects might carry on and achieve their status of construction. In this case, the RP is appointed as a company as a whole. So some issues are there in respect of overall administration.
So let's see what sort of amendment shall be there. Once we read the fine print of the amendment bill, then we'll be able to suggest better. Another proposal which is there is that enabling the resolution professional in a real estate company to transfer the ownership of the plot or flat to the allottees with the consent of the COC. To me, this was not barred earlier also, because this plot or flat in case of the real estate company is stock.
Yes.
It's not an asset. It's a stock. Like in a manufacturing unit, you can sell this stock, because you have to keep the company as a going concern. So similarly, this bar was not there earlier, but I think by way of abundant precaution or to provide a clarity, this proposal is being, this proposed amendment is going to be there.
Sir, what better could have been done in real estate? Because there are a lot of issues connected with real estate companies, where actually buyers are the ones who actually face all the brunt. So anything specific which could have been done as or introduced as part of the discussion paper?
Ankit, today is not the time, but I am going to propose certain major changes.
Any one or two, anyone, just hint.
Majority of my clients are in real estate sector only. And
That's why I know. That is why I asked you this
day in and
question.
day in and day out, everybody is facing the problem. When we'll finalize this suggestion discussion paper suggestions to the
We hold a specific webinar to discuss all those issues separately.
right. Okay. Approval of multiple resolution plans. Now, multiple resolution plans means there can be resolution plans for each unit now. It's
Bits
not
and pieces.
necessary for the entire company, there should be one resolution plan. And it says at least one of the resolution plans should provide for insolvency resolution of the CD as a going concern. It means in other cases, it may be buyout of the assets, but at least one resolution plan should be there, which keeps the entire CD as a going concern. It means some resolution plan may be there to purchase the assets only, because there will be a possibility that it's not a running unit. Only land, building, plant and machinery is there. And then there is a running factory. So for both the units, there can be different resolution plans. So the person who is buying a running factory shall be giving a resolution plan which keeps the corporate debtor as a going concern. And the adjudicating authority may approve these resolution plans in phases. जैसे एक application है approve किया, दूसरी है approve किया, तीसरी है approve किया, and once the last application is approved, only after that the CIRP period shall come to an end.
But then in this case, the person or the resolution plan of the company as a whole will definitely have to keep in mind the effects that are being caused by the other specific resolution plans.
No, but this resolution plan will categorically say that I am concerned with this particular unit, or the assets and liabilities of with respect to this particular unit will come to me. I will not be liable for the liabilities which have been there for the sake of the due from the other projects.
No, but the one who will give the resolution plan for the CD as a whole, he has to consider the impact of other resolution plans that are unit specific.
He will be considering, and I think that this plan shall be considered at last.
At last.
Yeah. Okay. Then they are suggesting separation of resolution plan and distribution of proceeds. Actually, if we read section 30, subsection 2, it is in two phases. One is that resolution plan is in compliance of all the applicable laws. And another segment is that there are two sub-segments, that the dissenting financial creditors shall be paid as per section 53 of the code. And then the operational creditor shall get priority over other creditors in case of repayment out of resolution plan. Now they are saying we need to keep these two apart. Resolution plan legality one side and distribution on the other side. And on the distribution also, what they are saying, we need to follow a waterfall mechanism on the similar lines like which has been proposed under section 53 in case of liquidation of the corporate debtor.
Okay.
And it is being proposed that the financial creditors shall get, to begin with, a value which is equivalent to the liquidation value of the corporate debtor. And then if after the liquidation value, if there is any surplus is left in the resolution plan, that shall be distributed amongst all these stakeholders in their respective share. So it means through this proposed mechanism, something is being provided for operational creditors also. Because till date, operational creditors were not getting anything, but now through this proposed amendment, OCs will also be getting something. That's my view.
But FCs will then only gain what is the liquidation value?
FCs up to liquidation value. That is their priority. That is the priority. After liquidation value, they'll be at par with others. Okay, the COC shall follow a challenge mechanism while approving any resolution plan. I think it's the same, the Swiss challenge mechanism, which we have heard earlier also, and we normally follow that. Monitoring of the implementation of the plan. Earlier, this monitoring committee was being proposed by the RA. But now it says the COC may provide for constitution of a monitoring committee. So COC is being empowered to constitute a monitoring committee to oversee the monitoring and of the supervising of the resolution plan.
Earlier resolution plan used to provide this, that who will be
The
there.
resolution plan was providing, and resolution applicant was keeping majority of its
Of
own
COC
nominees.
members.
Yes. Now, if there is any defect in any resolution plan which has been submitted before the adjudicating authority, now the adjudicating authority may remand back this resolution plan to the COC to reconsider it again. Earlier, this discretion was not there with the adjudicating authority. Reinstating CIRP. If during liquidation, if the company is a going concern and the resolution professional is of the view that this company can be revived, he can approach adjudicating authority, and adjudicating authority may revive CIRP instead of the continuation of liquidation process of the corporate debtor. I think this is a very, very welcome change.
But this will work if that would have been the case. The CRP would itself have got succeeded.
But Ankit, I tell you, there are now a number of cases. In case of liquidation now, there has been settlement under 12A. Some of the units are actually being revived under liquidation. Liquidation is no more the end of the corporate debtor. And that is a major change I have witnessed in IBC. And you know, in IBC, there is a provision that in case of liquidation also, the first effort of the liquidator will be to sell the corporate debtor as a going concern.
As a going concern.
That is the top priority. Even there also, they are not saying that you close down the company and sell the assets. No. First of all, selling the CD as a going concern.
And I've seen cases where it has been actually sold as a going concern.
Yes. Okay. Intermingling the assets of the CD and its guarantors. I tell you what exactly is it. Sometimes the directors are the guarantors for the loans of the corporate debtor. The land belongs to the directors, while the building and plant and machinery belongs to the corporate debtor. And now at the time of the resolution plan or at the time of the liquidation, it becomes very difficult how this land should be segregated. So now they are saying now there are going to be provisions that assets of the CD and the guarantors can be clubbed together, and there can be a common resolution plan or the liquidation process. How it will be done, we have to see the fine print in the amendment bill. Resolving interdependent entities. If two or more entities which are related with each other and they are into CIRP, registered office at different places. So two different adjudicating authorities are there. Two different RPs have been appointed. Now there is a proposal. In such cases, single adjudicating authority with one single resolution professional may be there. And IBBI will come out with the regulations for this purpose. Okay, this is again a fantastic amendment, and why this amendment is coming? Because of the 6th of September 2022 judgment of Honorable Supreme Court in case of Rainbow Paper Mills. You know what happened in Rainbow Paper Mills? There is a GST department of Gujarat state, and as per the GST legislation, sorry, sales tax, not GST, sales tax. And as per the Sales Tax Act of Gujarat government, if there are sales tax dues outstanding, the sales tax department shall have a charge over the assets of the company. Now this company goes into liquidation, and there it has been decided by Honorable Supreme Court that this state sales tax department shall be a secured creditor. They are not saying secured financial creditor, secured creditor. And if you read section 53, the top after the CRP cost and liquidation cost, the next in the line are secured creditors. They are not secured financial creditors. Even an OC may be a secured creditor. So what Supreme Court said that this sales tax department is secured creditor. So first of all, the secured creditor dues are to be paid, and then dues to any other person will be there. And then it went on, that judgment, that in every resolution plan, there has to be provision for payment to any government authority, state government, central government, any legal authority or any other authority. And unless the provision of payment to these authorities are there, the adjudicating authority shall not approve any resolution plan. Actually, that closed the window for insolvency cases, that particular judgment. That judgment has been reviewed. If you read today's newspaper also, in today's newspaper, there is a very big news in the Economic Times that that particular judgment has been sent for review, a petition for review has been filed, a notice has been issued. But now the government wants amendment in the code itself to take care of this judgment. And it says all unsecured creditors, because Supreme Court itself has decided that all government dues are operational dues. So it says all unsecured creditors other than the workman shall be treated equally under section 53.
They are now at par with other operational creditors.
And it further says all debts owed to central government or state government shall be treated equally with other unsecured creditors. It means this government dues shall not be called as secured creditors unless there is a transaction between the government and that particular corporate debtor. And if pursuant to that transaction, a security interest has been created, then only the government can be a secured creditor. But by virtue of any legislation, actually दिमाग में वही है, Sales Tax Act of Gujarat government.
Statutory dues है उनको basically.
Yes, all statutory dues shall be unsecured creditors and they shall be treated at par with other unsecured creditors. Okay. Information memorandum to provide an estimation of the valuation of the CD's assets. Earlier it was barred, but now I don't know why the government is want to make it open that IM shall provide liquidation valuation, estimation of valuation of the CD's assets. What they are saying, estimation of the valuation. Will it be fair valuation, liquidation value? That's not there. Because if liquidation value is provided in the IM, then certainly all the plans will be revolving around that liquidation value only. Otherwise, for all practical purposes, the RA, resolution applicant, is not supposed to know the liquidation value. वो मालूम चल जाता होने वो बात अलग है, but otherwise, practically they are not supposed to know that.
They will otherwise be prejudiced to some extent.
Yes. Okay, operational creditors who honor agreement with the CD after approval of the resolution plan. So during implementation, if there has been a pending agreement by any OC with the CD, and CD is ready to honor its commitments, the OC shall also be bound to honor its commitments with the CD. OC can never say, no, नहीं मेरा तो पिछले मैनेजमेंट के साथ था, आपके साथ नहीं है, तो मैं तो renew करूँगा इस agreement को. No. The all old agreements will continue provided CD agrees to discharge its obligations under the contract. Protection of resolution applicant. I think though we had enough provisions and the judicial pronouncements also, but still that was not being workable. So that is why it is being said that no proceedings may be commenced or continued by any government authority regarding the claims arising before commencement of CIRP, unless otherwise provided in the plan. It means once a resolution plan is approved, all those claims which have not been filed or which have not been admitted, they shall extinguish. CD's promoters' liabilities not to extinguish with respect to the banks and financial institutions. So if they have given any personal guarantee, those personal guarantees will remain. If any of their assets has been charged in favor of the banks can take those assets into SARFAESI and sell the assets. So CD's promoters' personal liabilities shall remain as it is. मुझे बता देना अंकित कब close करना है, because I may be having another 10 more minutes to complete this.
So then you need to hurry up, sir.
Huh?
Then you need to hurry up a little.
Yeah, I'll not hurry up. I'll close. You give me an indication, I'll close, because jaldibazi mein ye lage jo
you have I think 5 more minutes.
Okay, no issues. Okay. Now, computation of voting share, this I'm skipping. This also I'm skipping. Okay. Like in section 241, 242, 241 normally, we have seen that in case of certain companies where the affairs of the company are not being operated properly and the company is acting against the interest of the nation, interest of the society, or where some certain frauds have happened, we have seen that MCA or SFIO prefers an application under a petition under section 241 before NCLT. Now, taking a cue from there, now it is being proposed that central government may appoint its own administrator in case this company is a fit case for CIRP. So in such case, company will be under CIRP, but no resolution professional shall be appointed. Process shall remain the same, but the person who is there at the helm of affairs shall be an administrator appointed by the central government. Sorry. This also I'm skipping. Okay. As on date, the process under the code is first CIRP. If CIRP is no resolution plan is there, then liquidation and then dissolution. Now it is being proposed, and number of times we have seen that there is hardly any asset in the company. Companies was functioning from rented premises. There is no asset, maybe a simple table, chair, or a computer. That's all. No fixed asset. No recoveries, or recoveries are there, but they are not recoverable. They have become old, bad, old, and doubtful debts. So in such cases, the COC may request the adjudicating authority to directly dissolve the CD. No CIRP continuation, no liquidation, straight away dissolution of the corporate debt. I think it's a welcome change. Otherwise, I tell you, it takes sometimes 1.5 years to 2 years for dissolution of the corporate debtor. And in the meantime, every IP is incurring the expenses from his own pocket. Because there's no recovery. There's no money with the CD. Nobody is paying anything. There's no COC also in some cases.
And it will save the time to going through the CRP, then through liquidation. So all these things can be avoided.
Yes. Okay. Elimination of duplication of activity during CRP and liquidation. If a company goes into liquidation, then it's not necessary to get the valuation again. It may not be necessary to invite claims again. So what are the claims have been there with the CD? That shall be the list of the claimants, and whatever the valuation has been done during CRP, that shall be treated as valuation of the assets of the corporate debtor. It means it will save the time, it will save the resources. No doubt, if in the meantime there have been more claimants, the liquidator may be allowed to admit the claims, but the entire process which is there in section 38 to 42 need not be adopted. So therefore, there is a proposal to delete these sections 38 to 42.
Further reduce the time.
Yes. Okay. Role of creditor during liquidation. The COC will be there not to supervise and support the liquidation functioning. Earlier it was with the SEC. Now the COC will remain there, and COC may vote with 51% or more of voting rights. All the resolutions can be passed by the COC. Let me come to the last couple of slides because Anjali madam already giving an indication that it's
Sir, you may still continue, sir. No issues.
Okay.
I'm enjoying it, in fact.
Okay. In liquidation, there was no power with anyone to replace the liquidator. But under CIRP, there was a provision under section 27 that a COC may pass a resolution to replace the resolution professional. Now, similar provision is going to be introduced in liquidation also, and COC may pass a resolution to replace the liquidator, no doubt with the permission of the adjudicating authority. This also, okay.
I think it's a very huge discussion paper.
It's a very huge discussion paper, actually, yeah. Now it says that security assets which are their part of this liquidation estate. It says if all pari passu charge holders do not agree for realization of their security interest outside the liquidation process, then it shall become part of the liquidation process. Abhi tak, as on date, there is a provision under section 52 that if the secured financial creditors are of the view that I don't want this asset which is secured in my favor to be part of the liquidation estate, मैं इसको बाहर निकाल के ले जा रहा हूं, I'll sell it myself. And now suppose this asset is charged to number of financial creditors having pari passu charge. So it says if one of the financial creditors, if not in the, if is of the opinion, no, I want it to remain in the liquidation process only. But others want to be taken out of the liquidation process. But now proposed amendment says, if one of them says no, it shall become part of liquidation estate, it will become part of liquidation estate. And similar approach shall be there in case there is first charge and second charge. So even though it means the second charge holder will also now be having a veto power.
Wow. I think this is important.
This is important, but the bankers are going to oppose it. And this is the last slide, role of service providers and other stakeholders. Like in case of IPs, actually as on date, IPPI is not having any supervisory power or regulatory power to regulate valuers. They have power to regulate insolvency professionals, but not valuers. Now they are going to get similar powers to regulate valuers also. And last but not the least, is going to be a draconian proposal. IBBI may issue show cause notice without inspection or investigation if sufficient material is available on the court. It means no opportunity of being heard shall be provided to the service provider, and straight away, suppose somebody files a complaint against the service provider, say insolvency professional, and IBBI officials say, okay, yes, we are satisfied. This complaint has got sufficient material. Let's issue a show cause notice without seeking any clarification from the service provider. I think this is against the principles of natural justice and should not be introduced. This is my personal view. Ankit, with this, I come to the closer of this presentation.
Thank you, sir. Thanks for the wonderful session. I think there cannot be any better person to deal this subject. And I think you dealt it very perfectly. And we would like to continue if the time permits. But nonetheless, we'll try to have a separate webinar to discuss this. There are a whole lot of proposals. So thank you. Thanks a lot. I'll request you if you can wait for some time. I have a couple of questions for you.
Yes, please carry on.
I'll come back once we are done with the other participants, if you're okay with it.
After that, I'll not be available 5:30.
So I'll just have a couple of questions. Yes. So, but there is one question that I was told that there has been not more than handful applications on PPIRP. Is amendment 54A proposed due to this situation, as a lot of time was spent on coining PIRPP rules procedures at the time of introduction?
I tell you, on 1st of October 2022, when we had IBBI annual day and Madam Nirmala Sitharaman was there, and she gave a public statement there that we introduced these provisions of PPIRP on the basis of the recommendations received from the stakeholders and the industry only. But now once these provisions are there, it is not functioning. It's a non-starter. There is hardly any case under PPIRP. So let's analyze what are the reasons. And let's work together so that these amendments, actually those are amendments only, these amendments become successful. But still we have seen that this is not functioning. And as he has asked the question very rightly, according to me, this is the reason the government wants to know the reason. And I think reasons have already reached the government. And one of the major reasons was this giving submission of an affidavit by the directors of the corporate debtor that there is no avoidable transaction in the. Who will give this wrong certificate? But now if you do away with this, I think it may be workable.
Okay.
It may be workable. But मेरा ये भी कहना था, अगर PPIRP is workable, then certainly पहले जो CDR की proposal होती थी, those could have worked. वो भी तो यही चीज थी. Both banks and the company, they were sitting together finalizing the scheme. But that didn't work. That's why IBC came. Now in the IBC also you're introducing the same thing. The only difference will be here, this plan shall be approved by the adjudicating authority. There'll be a stamp. Otherwise, there is no other difference between the two.
And the last question is enabling the RP to transfer the ownership of a plot to an allotee. Is there a big challenge on constitutional validity that may be raised by real estate owners, as RP is not a de facto owner?
No, here my answer is, suppose this is a manufacturing company. Can the RP manufacture the products or not? Can they sell the products or not? If he can sell the products, can he sell the as stock which is lying there or not? If he can do all these activities, he can
I
sell
think so, yes.
flat also.
I think definitely. And owner
There
of the
is no-
company actually doesn't become the owner of
There
the
is no
flat.
constitutional challenge to this, I think.
Thank you. Thanks a lot for replying those two. And thanks for the wonderful session.
Thank you, dear. Thank
I'll
you
now
so
ask Ms. Anjali to carry forward the session and discuss the amendments on the capital market, basically securities law.
Thank you, Ankit. Good evening, friends. With regard to the securities laws, last one, there were not many amendments, but whatever amendments were there were only 2-3 circulars, but they have a far-reaching implications, which have to be kept in mind by all the compliance officers, by all the listed entities. First of all is the applicable provisions of CG provisions as were applicable under the extant CG provisions on InVEETs and REITs, which had issued their NCDs worth rupee more than 500 crores, now has been done away with effect from 1st April 23, will be done away with. These entities will now have to follow the governance provisions which will be brought in their respective regulations, that is InVEETs regulations and the REITs regulations. And SEBI proposes to make suitable amendments in these regulations by 1st April 23. So, next one, yeah. Now, this is a very important provision which has been amended with effect from 17th January itself. Now, the definition of senior management, which has been there earlier as well, but now it has been amended in the sense that apart from the persons who are already covered in the definition, the major persons will be added. It will be the functional heads by whatever name called shall also form part of the senior management. Now, this raises a very important question as to who all would be falling within the ambit of functional heads, because in any big organization, in any big listed organization, there may be people who may be, say, materials head or purchase head. Will they also be falling within the ambit of a functional head? So that is a big question, which I think SEBI should clarify upon. Then another important point is why this definition, why this amendment has been brought in. Now this definition has been brought in line with the with the definition given under the Companies Act. But if we try to compare between the utilization of the word senior management under the Companies Act and the way it has been used under the listing regulations, there's quite a distinction between the two, in the sense that Companies Act definition does not cast any obligation or any responsibilities on these functional heads. But listing regulations, when we talk about the senior management, it's being used at almost 10, 12 places in the listing regulations, and everywhere along with the board of directors, a lot of responsibility has been cast on the senior management as well, meaning thereby even that purchase head or sales head or materials head would be falling within the ambit of those compliance requirements. And in addition, under the listing regulations, a confirmation is needed to be given by the board of directors and the senior management with regard to compliance of the code of conduct, which has been formulated under the listing regulations. So will the said person be still required to, will also be required to file that confirmation? Is I have my own thoughts on that, and maybe my co-speakers can cover it up. Then, with regard
may I ask a question? May I ask a question on this?
Yeah, sir. Yeah.
Section 2, subsection 51 of Companies Act defines KMP.
Right.
And in the KMP, it has been defined that any officer of the company working one level below the whole-time director now may be appointed as designated as KMP by the board of directors.
Right.
And objective of that amendment, which was there in the through Companies Amendment Act 2017, was also that now the company can have as many KMPs as possible.
As many?
KMPs are not confined to 3 only
Right.
now.
Very right. Very right.
So if those functional heads, if they are made KMPs under the Companies Act and they are treated as senior management here also,
Right.
I think this will all lead to, number one, enhancement in the compliance level, in governance level, and mitigating the liabilities of the directors of the company.
I totally agree. I totally agree with that, sir. But then in every, and you know, that word used is by but whatever name called. There could be a person who's even, say, AGM purchase or AGM material. He would also be falling within the ambit of a senior management, and under the listing regulations, there are responsibilities cast on any senior management. So only to that extent. Otherwise, I totally agree. The ultimate objective is to increase governance level and to enhance the governance level.
Yeah, I think that there should not be any ambiguity. The guidelines regulation should provide clarity, not create ambiguity.
Yeah.
The one thing that bothers me, that why this word was earlier removed. It used to be there earlier.
Functional heads.
Yes, it used to be there earlier. I think in 2019.
Okay.
They deleted this word.
Okay.
I need to understand why they removed it earlier and now they have brought it
and
back.
Now they have included it again.
But as mentioned, the functional heads, they are also very important part of the management. And in big companies, there are big hierarchy in terms of CEO, vice president, vice president. Then there might be a functional head. But there are a lot of companies, there are functional heads who directly report to the CEO or the MD. So they part an important chain of the management hierarchy in the company. So, but this is what I found somewhere, that this was there earlier. So the rationale why they
let's cross-check this. It's an important point. Let's cross-check this one. Another amendment which has become effective from 17th January itself is that with regard to reappointment, earlier this confusion was there that reappointment is covered within the ambit of appointment or not. So with regard to reappointment of a director or manager, the company has to obtain the shareholders' approval at the next AGM or within 3 months, whichever is earlier. I think that's a clear provision. Yeah.
In this respect also, in one of the recent FAQs that are issued by the exchanges on the corporate governance report that is filed quarterly, there is a specific question on which they have answered that the appointment will include the appointment, though this was supposed to be clarified, because if you read the language, how it is framed, it seems it only applies to the person who are being appointed for the very first time on the board. But now, because of this amendment, this is also now clarified that the appointment of even an MD or a director will be covered under this clause.
Right, very right. However, PSUs have been exempted from this 3 months criteria. Shivam, next. With regard to the annual reports, the scope thereof has been expanded for the year 22-23 and thereafter as well. The details of all the material subsidiaries have to be given, including the date and place of incorporation, and the date and the name of the appointment of the statutory auditors of the subsidiaries is also needed to be given. One important amendment which is there with reference to change in control of various intermediaries which are registered with SEBI. For example, brokers, underwriters, merchant bankers, investment advisors, InvITs, AIFs, etc. So all these regulations have a particular regulation which talks about change in control. So all those have been clubbed as one regulation wherein change in control is being talked about. So in case of body corporates, in case these entities are body corporates, so if it is a listed company, then as per the SEBI provisions, it will be governed. However, in case it is not a listed company, then it has to be construed with reference to definition of control as given under the Companies Act, Section 227. And in case of these entities being non-body corporates, then change in its legal formation or ownership of, or change in the controlling interest is needed, is the deciding factor. Controlling interest has been defined as an interest, direct or indirect, to the extent of not less than 50% of the voting rights or interest. So if I am holding, say, 50% in a particular broking organization, then any change which will lead to a change of less than 50% would be considered as controlling interest, and accordingly a prior approval of SEBI is needed to be taken. Shivam, I think these were the amendments which were there in the securities laws. Apart from the amendments, we all are seeing the Adani fiasco, which is going in the market. Everybody, we as finance professionals, we as compliance professionals are, of course, concerned about it. And let's see how the things hold out. Ankit, over to you.
Thanks for sharing the highlights. We'll take any questions, if any, after we are done with Ravi. So now I'll request Mr. Ravi Prakash to share views on some of the recent judgments that are there.
On Anjali's point on Adani, 1,000 wala 1600 to ho gaya. Pointed out it was frozen at 1017, right. And later when
SPO withdraw karna pad jaye, to it's a big thing.
But anyway, I think the bottom is there. I think some corrective measures will be there.
Right, yes.
And today the finance minister, SBI, LIC, all have given a statement that the apprehension is not right. And SBI and LIC have said our stake is not much and stake is not at risk at all.
And they are actually at profit as of now.
Yeah.
God knows how far it is.
I know.
Ravi, you have to unmute yourself.
So very good evening to all, and I will focus on the judgments and orders that have been delivered in January 2023 in the realm of securities laws. And as you said in your part that the month has been eventful. Here in securities law realm also the month has been very eventful. We have seen SEBI's order of 625 crores that they ordered NSE to disgorge being turned down by Securities Appellate Tribunal on 23rd January. And also the disgorgement orders on the top brass of NSE, including Mr. Ravi Narayan, Ms. Chitra Ramakrishnan. They were directed to disgorge 25% of the salaries that they withdrew during the concerned period. As you know, co-location scam was a scam which was unearthed by a whistleblower letter, and famously known as a scam of 2015. Noteworthy is that the SAT turned down the order of SEBI on noticing the contradiction in their findings while dealing with two set of entities. One was the OPG Securities and the other was NSE itself, the first level regulator as they call NSE. So, and also in the order, it's a long order running in more than 200 pages. And SAT has remarked, and rather I would say SAT has come down heavily on SEBI in the order by saying that SEBI should have investigated the matter properly and with alacrity, rather than showing a passive approach. The investigation, as we know, was delegated to outside agencies rather than SEBI focusing on the investigation itself. And in one case, I mean, this is just for an instance, wherein one of the full-time members of SEBI was dealing with a matter pertaining to OPG. They said that the first connection or the early logins resulted into benefit of cornering other market participants or brokers, as the early logins or the preemptive logins allowed them to receive orders faster than others. But in the in the same vein and around and on the very same date, and while dealing with the other matter, it was held that early login did not confer any such advantage. So that was one of the point that the SAT looked at and said that we do not see that the matter has been judiciously decided or have been carefully examined. Now, why the order discusses a lot of precedents also from some from Western world, but the linchpin or I would say the heart of the issue, why SAT downturned the orders of disgorgement, was that there was no proof that either NSC or their officers, they had made any ill-gotten profits or they had avoided any wrongful gains. And all the judgments that you see, that the readers will find in the SAT order of 23rd January, it talks about the same issue, that disgorgement can only be done where there is a ill-gotten gain or wrongful loss that has been avoided. So it was none of that. In fact, SAT went one step ahead and they said that, you see, it is not really a case of violating the provisions of securities law. It is a case of lack in diligence on account of human error in implementing the circulars issued by NSC dealing with the co-location facility. Because if those circulars were implemented in their letter and spirit, probably the situation could have been avoided. Even after all these discussions, said that it would be unbecoming to let NSC go scot-free. And they impose 100 crore in Indian rupees on NSC to be deposited in IEPF, that is the Investors Education and Protection Fund, established by SEBI. And they said it would also act as a deterrent and the money should go in IPF. Now, that's one of the orders that has come in January. Second is the case of Aptech. The order was reserved back in July 2022, but has been pronounced only in January 2023. In this order, and this is quite interesting, this might be helpful for a lot of compliance officers who have to deal with, who have to administer or implement the provisions of prohibition of insider trading regulations. What happened in this matter is in 2016, Aptech entered into some agreement with a chain of schools called as Montana, international chain of schools, to open nearly around 1,000 schools, preschool, play school kind of arrangement for kids. And the announcement was made, although trading window was not closed. So SEBI picked it up and said, you have violated regulation number 9 of the insider trading regulations. In defense, and the matter traveled to SAT. In defense, the counsels for Aptech, they argued that the business of Aptech has been of education. So therefore, a tie-up in the field of education would not be an expansion of business. As you would know, expansion of business is enlisted as a deemed UPSI, and which is in the subclause 4 of the definition, which enlists that few information, if the information falls within any of these criteria, it is automatically deemed as UPSI, and there is no need of applying the test of materiality, non-materiality, and all those based on the policies that the listed companies have to develop. So this was the first argument that was advanced before SAT, and in support of these arguments, they also argued before SAT that no real purpose would be served if, in the ordinary course of business, trading window has to be closed, because then virtually it would mean that the trading window has to be closed for entire year or entire period. SAT answered the arguments in a very summary form, and rightly so, because a short issue was involved. They said that, see, once the classification is falling under the statutorily assumed UPSI, it is not open to argue that it must be tested, it must still be tested on the anvils of materiality. And they said for that reason, they dismissed the appeal. What is worthwhile to note is that the penalty imposed, although it is imposed under the residuary clause of penalty, that is under section 15 HB, but the amount of penalty is 1 crore rupees. And I am repeating again, the allegation was non-closure of trading window. Moving further. There's this case of Sanjay Dutt, Quantum Securities Private Limited. It's not Sanjay Dutt. This Sanjay Dutt is not the famous Bollywood actor. It's Sanjay Dutt who was associated with NDTV in past, probably during 2007 and 6. And due to his bad relations with the management at NDTV, he severed his path from NDTV, and thereafter there was some litigations between NDTV and this particular person. Ultimately, the matter reached to SEBI because NDTV had filed some complaints against this person, and this person had filed some defamation suits against NDTV. The charges which were alleged on him were of violating the insider trading regulations, because he was called to be a connected person, a person who was privy to the price sensitive information of NDTV throughout his tenure, as he was to head the corporate finance division of NDTV, or if not to head, then at least to play a substantial role there. And therefore, because of this position that he held in NDTV, he was privy to price sensitive information of NDTV. And then this person, along with his relatives and connected persons, traded into the securities. And the charge was that you have violated the provisions of insider trading regulations. Now, this is particularly interesting matter, because the officer concerned of SEBI who decided this particular issue, the officer did not go into the aspect of testing whether the decision of trading by Mr. Dutt and all other persons who were involved along with him were taken on the basis of UPSI. So, and because SAT found this, that the whole time member, that the officer concerned has not tested the case on the basis of this particular aspect, which aspect has been approved by Supreme Court in the case of Abhijit Rajan versus SEBI, which we discussed at length in a webinar conducted, where they held the tests, how in a case where charges of insider trading are leveled, what kind of investigation, what are the aspects you have to look at. And one of the essential aspects is that one must determine whether the trading is motivated by the possession or on the basis of the UPSI. Now, although the question of access of UPSI was there, but the aspect was not tested whether it was motivated by that UPSI. And these appellants, Mr. Dutt, Quantum Securities, along with all these people who are appellants in this particular appeal, and they also showcased before SAT that they, during the same period, they were also interested in quite other scripts, listed scripts, and NDTV was not the solitary script in which they had traded. And this was much after Mr. Dutt had severed his path from NDTV. Now, two important aspects that arise from this judgment. One, that SAT applied Abhijit Rajan's case here, and they said because this has been approved by Supreme Court and SEBI has not tested the case on these aspects, we remanded back to SEBI for fresh decision in accordance with law, because that cannot be called a proper examination or inquiry or adjudication. That's number one. Number two is that SEBI had classified, in its attempt to level the charges, a host of informations as UPSI. Now, SAT also expressed their view that certain information cannot be called UPSI merely because SEBI says so. it has to be tested on the basis of regulations and on the basis of the test envisaged in the materiality. So far as they are not falling under the automatic lists of UPSI, each and every information cannot be called a UPSI. And there is a judgment in the case of Pia Johnson from SAT, which lays down the criteria. Those criteria is long. They are objective as well as subjective. Therefore, I'm not going to put them here because of the paucity of time. But the case is of Pia Johnson, and one may read it from there as to what all criteria has been enlisted by Securities Appellate Tribunal to test when an information can be said to be crystallized to brand it as a price sensitive information. The appeal number is 59 of 2020. Decision was rendered on April 8, 2022. And then last but not the least, and I'm not claiming that I'm covering all the judgments, but these are the few which I found worthwhile to share with you all. And the last one is from my list, of course, is BP Equities, which is also rendered in January. Here, the charges were of fraudulent and unfair trade practices regulations. In short, the conspectus of fact is this. A person, along with its group entities, dealt into a script which was which did not have much traction, and the market float was only 0.33 crores, which is 33 lakh shares. But the group put buy orders for 10 crore shares in this very same script. The market was for only 33 lakh shares, but the group placed orders for more than 10 crore shares, nearly about 11 crore shares. So SEBI found it abnormal, and they imposed the charges of devious and deceptive trade practices, because the order book will lure investors that something is happening in this script and public will join in. And then you know what happens, that these people take their positions off and public is there to suffer. So SEBI picked up the matter and they imposed charges of FUTP regulations and held violations absolutely. Then appeal was filed before SAT. In appeal, a very ingenious argument was raised. They said that all these orders were placed, although the facts were admitted that market size was only 33 lakh shares and the order placed were for around 11 crore shares. But an innovative argument was taken that all these orders was placed by different dealers and not by one single person. And therefore, because they wanted to really buy shares in the scrape, they placed all the orders so in abundant caution so that they get the desired quantity from the market. But this was turned down by SAT. Although it was very emphatically argued, SAT said that, see, you should be diligent in dealing with the market, because your actions, how they reflect in the market, if they cause an inducement, if they are capable of causing inducement to others, that is the test. And it is not a new test upheld by SAT now in this case. It is a test which has been upheld by Supreme Court in many other matters, starting from the case of Kishore R. Ajmera and the cases that followed those decisions. And SAT held that, see, if your actions are capable of inducing others in the market, and that inducement is a fraudulent inducement, then we would hold you to the book. And they did not interfere with the order of SEBI, and the penalty was left unchanged. And that is all from my side, sir.
Thank you, Ravi, for such insights on judgments, specifically with respect to insider trading. Always been in hot matters for SAT and for the corporates. So thanks for sharing your insight. We have not received much questions. There are certain questions on MCA technical issues, which we are not in a position to reply. We understand there are problems in the current system, but this is suppose which MCA can only address. We cannot answer any solution at this point of time. There is a query, Ravi. Have you looked into? There is a recent SAT order on Satyam case asking CB to revisit. Have you by chance looked into this?
Yes, it is based on the premise that the investigation is improper, and they should look into the aspects which are not yet examined or not yet properly examined.
Who has filed the matter?
Well, those details I need to still call out,
Okay.
but it appeared in the public domain, and I read it from the news articles itself, the coverage through platforms that they are some appeal, some that kind of development has occurred.
Okay, thank you. Unfortunately, we don't have any further queries to resolve on the chat box, and no such other queries have been received. Thank you all for giving your precious time today, and it's been a wonderful session. Thank you. We'll meet again next week. I am